Good afternoon, ladies and gentlemen, our esteemed viewers at home. Welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issues of law, politics, and governance. We welcome you to the last Sunday of the year 2023, and we are excited. You have been part of our journey throughout the year, and we are very, very thankful for your steadfastness and ever consistent presence in this show. Before we go into the topic of today, we would like to take a look at our highlights, for the year 2023. Of course, next week we'll have an overview of our 2023 programs. But before then, we'll look at the highlights and some of the topics that made the headline. We looked at the Naira redesign policy of the federal government, at the course of the year. We look at the Supreme Court affirms President Tinubu's election. These are some of the highlights of topics we looked at with you last year. We'll look at the Supreme Court fines Ozekome 40 million. We have looked at the not so distant past. We looked at the crisis rocking the Rivers State House of Assembly. We looked at the case of Amiefile and so many more. Next week we'll have a general recap of all our topics for the last for the 2023. But for today's edition, we'll be looking at three important topics that have made the headline during the course of the week, and also that has impact in the issue of democracy and the rule of law, which is the core objective of this program. So the first topic we'll be looking at today, we will look at the conflicting judgment of election petition cases and its effect on our democracy. You can all agree with me that the court is an important ingredient of democracy and democratic principles. So we'll be looking at that vis-a-vis our democratic journey. And secondly, we'll look at the 2023 general election, and its unmet expectation, according to which is arguably, of course, according to some of the electorate who feels that there are hope for a transparent, and free election was dashed. We'll look at that. And finally, we'll look at the recent decision of the Supreme Court on the case of the Federal Republic of Nigeria and Nnamdi Kanu and the constitutional implication of that decision. So before we introduce our guest, who is already seated in the studio, this afternoon, we'll go on a very, very short break, and when we come back, we'll take this topic one after the other. Stay tuned and don't go anywhere. We'll be back very soon. If you are just joining us, you are on to your favorite program, Democracy and the Rule of Law. With me on the studio this afternoon, I have Barrister Obiora Ome, an ever-present guest on this studio, who have helped us in so many ways to make sense of so many issues that have cropped up in the course of the year. Barrister Obiora Ome, welcome.
Yeah, it's my pleasure to be here once again, and I thank our fellow Nigerians and viewers of this program for their understanding. They are key to this wonderful program.
Yeah, thank you very much for that brief introduction. My name is Kenneth Mimo, as you all know, a legal practitioner and your host for today's edition. So, Barrister Obiora, before we begin the show, I want to thank you for your ever-present and your insightful analysis has not only been acknowledged by viewers and also been acknowledged by policymakers, and has influenced a lot of policy in terms of deepening our democracy and policy decision around all of these issues. So I want to really appreciate you, for your insightful decision, and we are also looking forward for better analysis this coming year, 2024.
Thank you for the observation. I will believe God that we will all aspire to make things better.
Thank you very much. So yes, we'll just, without much ado, we'll go into the discussion for today's edition, because I know that the viewers will be eager to get your more insightful decision from you. So first, we'll look at the first topic for today, the conflicting judgment of election petition cases and its effect on our democracy.
Yeah.
So, Barrister Obiorome, we want to really conflicting decision. You are a lawyer, and there are rules to these things. It has been very, very, of course, we have had conflicting decisions in the past, but it seems to have heightened in the last election, especially on issues of electoral matters.
Yeah.
So what is so special about electoral matters that that warrants the frequency of these conflicts in the decision of the court when it comes to the nature of these cases?
That question is precisely the reason why Nigerians appear to be worried. In other matters, civil matters, criminal matters, land disputes, and so on, these conflicting decisions are few and far between. They are not that consistent and always cropping up. But we've observed in the electoral matters, in Nigeria, particularly this last election, that there are so many conflicting decisions of the courts. And that has made a lot of Nigerians to be worried. And some are even asking questions that, do they still have hope in the judiciary? In fact, during the election period and before the judgment of the Supreme Court, there was a hashtag, all eyes on the judiciary, meaning that everybody is expectant that the judiciary will come up with decisions that appear to be in line with the expectations of the masses. And then for those that are not lawyers, we want to explain that in Nigeria, we have hierarchy of courts. The highest in the land is Supreme Court of Nigeria. We have the Court of Appeal, we have the High Courts, Federal High Courts, that of the states and that of the Federal Capital Territory. Then we have customary courts, mandatory courts, and others. Now, the Supreme Court being the highest court, its decisions are binding on all other courts under it. Now, at the Court of Appeal, there's one Court of Appeal and many divisions of the same court, meaning that the decision of one Court of Appeal is the decision of all the other Court of Appeals. We have just one. Now, in the election just concluded, there were decisions that appear to be conflicting, and Nigerians find it difficult to fathom, to explain why this thing should be so. For example, in Plateau State, in the judgment that removed the governor, the court considered the pre-election matter and treated it that it qualified to be taken by the court, and then after an overview of the pre-election matter and the petition presented, the court gave its judgment. Now, the same court in its Ebonyi State division, the Court of Appeal in Ebonyi State, faced with the same matter. And what is that matter? And the governorship election, that pre-election matters cannot be taken at the election petition cases. That pre-election matters must be concluded before the election itself. And of course, we know that that principle of law has its origin or paternity in the case of Okafo and Oroha. That's in 1983 decision of the Supreme Court, where the Supreme Court tried to draw a distinction between matters that came up before the election itself and matters that came up at the conduct of the election. And the Supreme Court in that matter said that pre-election matters should be treated before the election, and then election matters treated at the election and post-election cases. So, at Ebonyi State Court of Appeal Division, the court said that could not delve into the pre-election aspect of the petition presented. The same thing happened at Benue, and then that led to different conclusions on the same matters. Then there are judgments that are also conflicting. And the question now is, will the conflicting decisions and judgments, especially on election petition cases, what is the hope of our democracy? Our democracy is nascent, and in recent years, a lot of people have not been giving kudos to our democracy. And then I think that there's a way out.
No, but before we go to the way out, there has been this argument,
yes,
by the people that democracy grows when the citizens' vote count. When the citizens' vote count.
Yes.
And one commentator had said that the growth of democracy can only be guaranteed when the votes of the people count, and the judicial system can be counted upon to ensure justice when rights are unjustly abridged. Where am I going? The influence of the judiciary seems to, in electoral decision, in recent time, it seems to have grown so big, to the extent that some persons are losing confidence on the fact that it is actually the judiciary that are now in charge of installing or putting based on what is decided. When you look at other jurisdictions, yes, for instance, the US, that is where we borrowed our yes, democracy is. Yes. You hardly find their court interfering with the decision of the people. Yes. They make sure that the votes of the people count, and the votes of the people are supreme, and they try to minimize their influence. For instance, there's a recent decision of one of the state courts that seems to bar the President Trump, who is seeking for to be removed. Yes. And legal commentators have said that that decision is predictably going to be nullified by the Supreme Court. Yes. Because they believe that the court should not interfere in the choice of the people, that the court should allow the people to choose who they want to govern them. So why can't we replicate that in the system? Because the influence of the judiciary, almost 500 and something election petition cases in the last election. Yes. So what is the way out?
Yes. Yes, you see, what we have known over the years is that once the Supreme Court has given its judgment on a particular matter, on a subject matter, it becomes settled law. Any lawyer anywhere can rely on it, and if he has a similar case, can predict what will be the outcome of a case on that point, because the Supreme Court has decided. And that is the principle, binding precedent of the Supreme Court decision on all other courts. But in recent years, we have seen instances where some courts, especially the Court of Appeal and even some High Court judges, depart from Supreme Court decisions. And this has been termed judicial rascality. Because how can a Court of Appeal judge or a state High Court judge go outside what has been settled by the Supreme Court to something else? And even the Supreme Court itself, in recent years, has not been consistent in its own decisions. And that is what has brought what we are witnessing today, conflicting decisions, even of the Supreme Court. For example, in one of these political cases, the Supreme Court said, look, there is no room for technicality in Nigerian judicial system. That what the court is out to do is substantial justice. Nothing less than that. And then you see other cases where the Supreme Court has now gone back to still look at technical issues and use that as a launchpad to come to conclusions on matters.
And to think that this issue of lack of certainty has
Yes.
now emboldened litigants, and that
Yes.
is why you have so many cases, because you believe that you will always you can have justice.
Yes,
can
and you see, it has affected legal practice, it has affected lawyers and the general public, because in years and years when you can predict what will be the outcome of a case, you can advise your client as a lawyer, and don't worry, this is what is likely to be the case. You know, of course, you don't assure that you said with all, because you already know what the law says, what the judgment is got on that area of law, that subject matter is. But today, there is no such certainty. And then it is giving room to some people to make speculations, allegations. You know, some of them claiming that there are other determinant factors apart from the evidence before the court. That some waters do pass under the bridge that we don't know about. Of course, we know that some people have come out to accuse, you know, some judges of corruption.
Yeah, even some of the judges' spouses, like the bookatualization of the investing. Yeah, I've said that they help
and
sometimes.
Even the retired Supreme Court Justice,
yes, has also accused
he
his
came
colleagues.
out to say openly that there was corruption.
Yes.
And even in the Supreme Court. And then but he now made recommendations to sanitize the system and then show that the confidence of the masses is still restored in the court. Of course, we know that the judiciary is the backbone of democracy. But what we are saying in Nigeria is not what is in other jurisdictions. Like in the US, you have mentioned, in Nigeria alone, in one election, we have over 520 cases, petitions, in one general election. Over there, it is the voice of the people, the mandate of the people, expressed through the ballot, through their votes, that counts. In Nigeria, it appears to be the norm that it is the court that decides who becomes the president, the governor, the senators, and what have you. There are people in instances where people that do not follow due process in this election matters. When I talk of due process, I'm making reference to compliance, the Constitution of Nigeria as amended, and the Electoral Act 2022. There have been instances where people that did not participate in the primaries of their political parties eventually coming forward and being selected after, you know, their primaries and being forwarded. And then these things don't, you know, advance the cause of democracy. Because at the end of the day, when the courts come up with decisions that a particular person who did not even buy form, or a particular form that is meant for that of it, let's be specific. The Senate president, he had the ambition of running for the presidency of Nigeria under APC. He bought a ticket. Eventually, he did not clinch the ticket of APC.
You said the former Senate president, because the Senate president is Akpabio now. That's the former Senate.
The former one, yes.
Yes,
the former one. Sorry. So, now, and eventually he became the...
Oh, I think the Senate president, even this one was also part of the district, because he contested for president.
Oh, yes.
I think Akpabio also.
Even Akpabio,
yes.
Both the former, even Akpabio, he got the ticket. Yes. Akpabio got the ticket. And I don't know, which meant that the form he got was that of the presidency, not senatorial seat. But at the end of the day, we find him at the Senate, not just being there as a member, but as a Senate president. You see, so we want a situation where Nigerians will have confidence in the judicial system when it comes to electoral matters, electoral petition cases, and then this first issue of election matter that is a no-go area, that once it's raised, the courts, like Pontius Pilate, wash up their hands. We need to look critically at that. Is that really what the law says? What the Supreme Court said in 1983 concerning relational matters not coming up. Now, what is the position of the law vis-a-vis the 2022 Electoral Act, Section 29, 5 and 6? The exceptions there, are they not enough grounds for members of political parties or aspirants to explore, and then the courts having the decision to look into those matters? For example, that section 29 of the Electoral Act 2022 has paragraph 5 and 6 as its exceptions. Now, the main provision says that notwithstanding the provision of this act or rules of a political party, and aspirant who complains that any of the provisions of this act and the guidelines of a political party had not been complied with in the election or nomination of a candidate of a political party or election may apply to the Federal High Court or the High Court of State or FCT for redress. What it simply means that if there is no compliance with the Constitution of Nigeria as amended, or the Electoral Act, or the Constitution of the political parties, or the guidelines, an aspirant can go to court. Now, 5 and 6 also has an exception that the provision donates to members of political parties the right to contest in court where a candidate give us information in the affidavit or any document submitted to the Independent National Electoral Commission. Now, what we have seen in the recent past is where once a matter comes to court on the issue of qualification of a candidate to contest an election, be it president, governor, senate, or whatever, then they will say, well, that one is an internal affairs of that political party. It is their internal affairs that the court should not interfere. Or there is a pre-election matter. We know that the Constitution is the ground norm of this nation, Nigeria. And being the ground norm is the law, the Constitution that binds every other than anything, act, conduct, action does not consist with the Constitution is null and void to the essence of inconsistency. And that gives us the only receivable conclusion, which is what? That anything that is not in line with the Constitution is null and void, and the court has a duty to do what? Declare it null and void. Huh? Looking at that, and what has happened in the recent past, where a party from one political party sees another candidate of an opposite political party did not comply or gave wrong information or false information in the form or affidavit, then the court will say you don't have to interfere. That is wrong. Okay. As far as I'm concerned, with respect to our courts, the Constitution has said that any person who finds out that there is no compliance with either with the Constitution or the Electoral Act or even the Constitution of the parties or their guideline should go to court for redress.
Okay, thank you for that beautiful point. But before we go on a break, I want to quickly ask, because this issue of conflicting judgment has been more rampant at the appeal court, probably because they have several divisions. Yes. And for one of the examples is, you know, there's a case that an issue of one court, one of the division of the appeal court have said that blue biro is inconsequential, you know, that as prescribed in the manual. Yes. Then another division of the court, when the same issue arose, it says that it must use a particular biro. Yes. And another issue is another case too, in the same division of the court, where one division have said that non-inclusion of a candidate's picture and logo was not consequential in the overall while another one says otherwise. So my question is that, unlike before, where we have all cases ending at the Supreme Court, what we now have is that some cases will be terminating at the appeal court.
Yes.
I think it's only the governorship and the president that will proceed to the Supreme Court.
Yes.
So the appeal court now has enormous final decision on some cases,
yes,
which makes them almost like a Supreme Court. So with all of this thing hanging on their neck as they relate to conflicting judgments, so where do we go from there?
Yes, I'll tell you where we go. Where we go is to allow other election petition cases still terminate at the Supreme Court. And how do we achieve that? We know that the Supreme Court is overburdened with its workload. But you discover that there is no way any normal person, a reasonable man, will go home thinking that all is well when the same court, to different divisions, are coming up with irreconcilable judgments, conflicting judgments, like the color of the blue barrel and all that, inclusion of passports and so on. These are clearly conflicting. The same court in one decision will give one judgment, another will give a different one. So now, what I think is the way forward is, let the Supreme Court have the opportunity to correct these inconsistencies. And the way to go about that is to, one, change our electoral calendar. What I mean by that is that in an electoral cycle, elections should be conducted 1 year ahead of the time for the new elected officers to assume office. So that we have 1 year within which all these matters should be taken by the court or to the Supreme Court. Of course, I know that they normally give it attention and expedite action. So that, because that is the only way to restore the content masses in the judicial system. And again, it will give the people a sense of justice. Once a person has taken this matter to Supreme Court, if he loses there, he will now know that the next appeal is to heaven. And there is only God that determines that. So on earth here, let us give people the opportunity to ventilate their grievances. Let them not go home feeling that, well, they have been shortchanged, they have not been given justice or fairness. Let us have opportunity of at least the presidential election, governorship election, and then that of the National Assembly can allow them to get to Supreme Court, particularly where the appeals don't terminate at the Court of Appeal again, because the divisions of the Court of Appeal, they are just divisions of one court. And if you now, how do you now go about it? You cite the decision that favors you. If you did not put the passport, for example, then the other person, the other opposing counsel will cite the one that's against it. Then what will be the outcome?
Confusion.
That is confusion. So it's better that we go back to the drawing board, look at it holistically, know that even the time frame to present petitions is short. 21 days. A presidential election petition, you have to do 1 day to gather all the evidence, documentary and otherwise, package everything and present. The time is short. There's need to amend the Constitution and the Electoral Acts and extend that time. And like I suggested, if there could be a period of 1 year within which all these things can be tracked out.
Okay. Thank you very much for that wonderful perspective. So we'll go on a very short break, and when we return, we'll take the next topic on our list, which has to do with INEC and the restoration of confidence on that important national agency. Stay tuned. We'll be back very shortly.